Keep us posted if there's things happening in teams that we should know about. My name is Big Hartman. I use they, them pronouns. I'm the Executive Director and General Counsel of the State of Vermont Human Rights Commission. Thank you for those of you who are here in person. Thank you for everyone who's joining from around the state. I think I already said, but I'll say it again. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. And so my presentation today is entitled How the Vermont Human Rights Commission Works. I am going to talk a little bit about that, but as I was developing the slides for today, I thought it would be worthwhile to just go ahead and do like a mini Know Your Rights kind of training also about the different laws that the Human Rights Commission is responsible for. Okay, I just felt like in these times, folks might appreciate knowing a little more about our state law anti-discrimination protections. Thank you so much for coming here today. Really been looking forward to this presentation. And I went to this conference last year. It's just such a great group of folks that come together and talk about such important issues. So a little bit about me. I am an attorney. I've been an attorney here in Vermont for about 20 years, believe it or not. I joined the Human Rights Commission as a staff attorney investigator about 4 years ago now, and I've been executive director for about a year and a half, almost 2 years. It's really one of my favorite things to do is to get out and share more with folks about what we do and how we work. So just a quick little agenda for you so you know where we're headed today. I'm going to give you a little overview about the Human Rights Commission and who we are. I'm going to talk about our complaint process and what that looks like. And then I'm just going to go through the 3 areas of the HRC's jurisdiction: fair housing protections, public accommodations protections, and employment. And I am going to focus, since the topic today is accessibility, I'm going to be focusing on what are our protections for people with disabilities in those 3 areas. And I can talk all day about these topics. We're going to try to squeeze this into about 50 minutes so that there's time at the end for questions. But also, I encourage you to go ahead and, ask questions while we're moving along here. That's totally welcome. So if you're remote, you can either raise your hand or just type your question into the chat, and Danny will let me know when that happens. And over here, just feel free to shout out, raise your hand, whatever, engage with information. And I do have some hard copies of the slides in case you like paper copies. I have a few here where you can take little notes on the side. Okay. So just a little overview about the Human Rights Commission. It's actually still surprising to me how much folks don't know who we are, what we do, how we work. So we are a state agency. They're independent. We are not a subpart of any other agency or department. We are all state employees funded primarily from state tax dollars. We have about 10% of our funding right now that's come from HUD for our fair housing work. Our mission is to promote full civil and human rights. So we're working to protect people from discrimination by investigating complaints, helping to resolve those complaints, filing lawsuits. I will be here to point out all of my typos in my slides. So we file lawsuits, not lawsuits, and we try to do as much education and outreach work as we can. So if you're like a law geek like me, you can go and check out our enabling statute in Title IX. I put the site in there. And we also have administrative rules on our website that dictate kind of the day-to-day processing of our cases and all of that. Downstairs and on our website, you can grab copies of a guide document that we created last year, which is meant to be a plain language guide based on information I learned at this training last year about plain language and accessible materials that just tries to help people who are involved with complaints or thinking about filing a complaint know more about our process and what to expect.
Question about the title of the books, you know, the title of those books.
Yes, we have two sets of books downstairs that relate to fair housing. The Color of Law by Andrew Rothstein is thought of as kind of the seminal book about redlining and the history of segregation in the United States. And then he partnered with his daughter, who's a community organizer, a couple of years ago, and they published a book called something else, and that will come to me. That's more about, like, it's kind of like a sequel to it. It's like, what are communities doing about segregation now? And it's kind of a little bit more of a like solution-oriented book instead of just identifying the problem. But they're both really great books, and we happen to have a few free copies left, so we thought we would bring them here.
Someone said it's just action.
Just action, thank you. Oh, right, I appreciate the engagement and helping me. Okay. So our staff is smaller than I would like it to be perfectly honest. You may know that I am very busy at the State House this year trying to enable us to meet the needs of our times. But this is the staff that we currently have, myself, the executive director. I'm generally overseeing our intake, our legislative work, our outreach work, and our complaint processes. We have an executive staff assistant who's our administrative person, 3 staff attorney investigators. So the people who are investigating cases are all attorneys. We only have 3 folks doing all of the anti-discrimination complaints that come to our office across the state. It is woefully inadequate, results in cases taking a lot longer than we would like. And it often also means that we have to decline to take certain cases that we would otherwise take if we had the capacity. Any of you who are state employees probably know how hard it is these days to get the work done with the resources that you're allotted, but we're all doing just the best we can. We have a director of policy, education, and outreach. Amanda Garces has been the person who holds that position over the last 5 years. Some of you may have come in contact with her. She has just moved on from our office to the Truth and Reconciliation Commission, and that position is currently vacant. And we also have a senior counsel, which is our newest position that was created just about 1.5 years ago. Really exciting. Finally, we have someone in-house who can handle our litigation and enforcement actions in court. So that's a really exciting way that we can expand our impact on the state and on enforcing our statutes. I'm going to try to talk fast, but if it's too fast and it's making you crazy, let me know and I'll slow it down. We have 5 HRC commissioners. So these are just citizens. These are non-lawyers. These are regular folks who are appointed by the governor serving 5-year terms. Commissioners meet once a month, sometimes even in this room, and we discuss HRC business and hear cases in executive session. And they will come out of executive session and make a determination on any case that they're hearing in the public session. Those hearings that we conduct tend to be pretty informal, and they are confidential, though. It's not like an evidentiary hearing where we're putting forward witnesses and things like that. It's really just a chance for the parties to communicate directly with the commissioners about our investigative report and whether they agree or disagree with it. I'm feeling like, oh, sorry, I thought I was missing a slide, but it's ahead. So the commissioner's role under statute is to make determinations about whether or not there's reasonable grounds to believe that discrimination occurred. They also will vote to approve a lot of settlements in our cases, which are public records under our statute. And we'll talk a little bit more about what kinds of cases they hear. So under state law, as I mentioned, we have 3 main areas of our jurisdiction that we're enforcing. The Fair Housing Act, the State Fair Housing Act is our most common number of cases are falling under fair housing. We'll talk a little bit more about what exact protections folks have. It's generally the comparable to our Federal Fair Housing Act, and our contract with HUD enables us to do investigations that are implicating both state and federal law. So it's kind of like a dual file situation there. But our fair housing protections in our state law and under all these laws are often more expansive and more protective than kind of the federal law that sets like the base of protections. Places of public accommodation is our second area of anti-discrimination protections that we have jurisdiction over. We'll talk a little bit more about what those mean, but often this is ADA type protections that exist under state law. As well as other protections against other forms of discrimination like racial discrimination and sex discrimination. We are all protected from being discriminated against in these places, both in our housing and when we go out into the public and interact with businesses, government, schools, hospitals, hotels, all of it. In the employment, on the employment side of things, there are actually two agencies that handle discrimination complaints. Our office only handles employment discrimination complaints involving the state of Vermont as the employer. All the other employment-related discrimination claims are going to be processed by the Attorney General's Office Civil Rights Unit. That's just the way our state works. I haven't found other states that do it that way, but hey, we're just working with what we got here. At the Human Rights Commission, our process contemplates that at any point, a case is going to be potentially resolved through some kind of settlement or some kind of agreement or some kind of resolution that the parties decide we're not going to move forward with an HRC complaint. And we are often tasked with helping the parties work something out, kind of as a neutral in between, you know, kind of go between to relay those conversations about settlement. But our investigation process starts over at the end with intake. Intake happens over email and phone primarily, although sometimes people will just show up at our office in Montpelier and tell us that they want to file a complaint. So we usually will review any documents that folks want to present to us, and we will often have some kind of intake meeting with them, either by phone or in person or over Zoom or Teams. Sometimes we just need to fill in a few details over email. It's kind of like whatever works best for that particular, what we would call complainant. So someone who wants to file a complaint with us is called a complainant. The person they're filing a complaint against is called a respondent. We can't take every case that comes our way in intake. I honestly wish that we could, but that, like I explained already, we just have very limited staff. So we do have to be somewhat selective in accepting complaints for investigation. Right now, as we sit here today, I've got 100 folks that are in an intake process with our office, and we have 68 investigations that are underway.
Is there a common place you refer people to if you don't accept a complaint?
There is no comparable state agency or office that will do an investigation. So it's really hard when we turn people away. But there are a lot of folks are contacting us about some issue with their housing that isn't actually discrimination. It's some other dispute with their landlord or something. So we will often refer folks that are dealing with housing issues, whether we can help them or not with an investigation. We will often refer them to two primary agencies. Champlain Valley Office of Economic Opportunity, CDOEO, or the Housing Discrimination Project at Vermont Legal Aid. Both of those agencies, as you may have read, have just been informed that they are not getting as much HUD money as they had been counting on for this year. So we're really concerned about that reality, that they're really, and those folks are serving as like advocates, you know, and providing more like advice to folks. Our office is just doing investigations. So we often aren't able to provide the kind of advice about what should I do in this situation as, you know, we might like to be able to do. But because we're an agency that does investigations, we're really, you know, we have to be really careful about not giving either party any legal advice and just really trying to maintain neutrality throughout the process. Keep shouting out questions. I love it. On the, so once we've notified somebody that we are able to accept their complaint for investigation, we assist parties by drafting complaints. And then once that's like all finalized and notarized, our office sends notice of that complaint to the respondent, the people or entity or person who the complaint is filed against. And then our staff attorney investigator conducts very comprehensive investigations. This is going to be an opportunity for any party to provide documents to our investigator, to participate in an interview with our investigator, to ask questions, let us know anything they want us to know about what kind of their side of things. Sometimes we'll also gather information from like third parties. There might be a police report or a witness that will really be trying to find out as much as we can about the whole story. And then our investigator is also trying to, in those conversations with the parties, try to see, can we solve this problem? You know, can I, as the investigator, facilitate a conversation between these parties who may not be communicating directly very well, and see if we can make this complaint go away. Honestly, I wish that we could find more resolution before a settlement process, but folks don't seem super willing to engage in those conversations during our investigation process. I think a lot of parties want to see the investigation run its course and kind of have their day, you know, and their story told. So that's, you know, a service that we provide for folks. And once we've gathered all the information we can, our investigator will write a investigative report that contains a summary of the facts, the witnesses that were interviewed, and a legal analysis about whether or not we believe there's that reasonable grounds to believe that discrimination occurred. Our investigative report gets shared with the parties and the commissioners. The parties, the complainants and the respondents, have a chance to write or talk with the commissioners about whether they agree or disagree with anything in the report. And then the commissioners, like I already said, will have that commission meeting where they make a final determination about whether or not there's reasonable grounds to believe that discrimination occurred. That entire process is confidential. Talk a little bit more about confidentiality on our next slide, but that's often something folks want to know. The existence of a complaint is confidential. The investigative reports are no longer disclosed publicly. The parties can share whatever they want with whoever they want. The Human Rights Commission has pretty strict confidentiality requirements under state law. And then after the commission meeting, so if the case goes no reasonable grounds, then that's basically the end of it. But the parties have the benefit of having gotten to say their piece. They have the benefit of access to our complete investigative file, which sometimes is very helpful. So for some other claim they may want to bring. And that's the end of that matter. If the case goes reasonable grounds, it's still something that we're working on. So our statute says that we have 6 months to try to work with the parties to see if there's a settlement that can be reached at that point. It's much easier to get a settlement at that point, often because now everyone has the benefit of seeing kind of what were the facts, and there is this determination that probably some discrimination happened. If we aren't able to work out a settlement, we have the ability to enforce those state law protections in court, where we, the Human Rights Commission, is the plaintiff, and it's against the respondent. Sometimes folks don't want the Human Rights Commission to take the case. They want to do it themselves. They have other cases, they have other claims they want to make. They have a lawyer, and that's totally fine. At any point in this process, somebody can go ahead and file a case in court. You do not have to go through the Human Rights Commission process to enforce your own individual rights under state law. And we don't have the capacity to litigate every single case, but we have more than we ever did. Historically, it was the job of the executive director to do all of the litigation. So we kind of have like one case going at a time. Now that we have a full-time litigator and we have been processing cases more quickly, we have 16 cases currently that we have filed in court. But with court, it's not like the court is going to give deference to our investigative report or our determination. It's very beginning of a case, a lawsuit, we have to satisfy the burden of proof. It's, something that could go in front of a jury, it's like the very beginning of the process. But everybody has all the information that was gathered through our investigative process. So that's the overview of the complaint process. I know that was like a ton of information. Any questions about the Human Rights Commission process?
I have like one question, and this might be a can of worms. But I believe I heard you say that the HRC only investigates, it was where employment is concerned, it's state employee complaints. How does that ever intersect with contract complaints that are filed with the SEA? Because they also have their own lawyers. So I was curious if maybe that's not a thing that those two things never overlap, but do they ever overlap where a contract complaint also is a Human Rights Commission investigatable complaint, and how would you resolve that?
Yes, it's my impression or understanding that the collective bargaining agreement that the SEA has also prohibits discrimination.
Yeah.
Discrimination is still illegal, whether it's under a collective bargaining agreement or under state law. So generally, parties kind of choose one track. If they're going to grieve that through the labor board process or arbitration, they're going to go that track. If they're going to want to bring it to the HRC, often we do see the VSEA kind of referring union members to us to file complaints. But they don't have to do that, and you still have your grievance rights.
Sure.
But if you have a grievance process going on about the same exact set of facts, we probably wouldn't be inclined to investigate that because it's already being processed elsewhere. We wouldn't want to have a situation where we end up with two different findings of fact. That could be tricky. So great question.
Great, thanks.
Your question here.
Great.
in the chat. So does HRC consider the financial ability for someone to bring their own case independently when deciding to take on a complaint?
No, I wouldn't say that that's a factor that we consider in the intake process. It may be a factor we consider when we're deciding whether to go to court with a case. Like, is this person going to be able to have access to justice some other way? There are a number of factors that we consider in the intake decision point, which is probably the hardest part of my job, is having to say no to certain cases, which maybe have merit, but I don't have bandwidth. A lot of the decisions I'm making there are about resources that our office has, and where our caseload levels are currently at. Also, folks have to get in the door within 1 year of the last discriminatory act. So if someone's coming to me 3 years later, they still have a right to file that lawsuit, but our rules say allegations have to be made to our office within 1 year of the last discrimination thing that happened. So sometimes that's a factor. And sometimes it is a little bit about the merits or the complexity of the case that might be a factor in helping our office decide whether to decline or accept a case. Good question. My preference would be to accept all the cases, but that's just not what's possible right now. And just a quick note, because we do get a lot of questions about confidentiality, we get a lot of public records requests that we can't respond to meaningfully because of our rules and statute about confidentiality. So as I said, complaints are entirely confidential. A complaint that's under investigation or in an intake process, our office cannot say anything to anyone about whether a certain person has a complaint filed against them or is a party in a complaint or anything like that. But, and the investigative file, any information that the investigator collects and puts in their file is only available to the parties. It's not available to anyone outside of the case. And it's not available to witnesses either. Our commissioner decisions are, they're technically public in that you will see a case number and a vote. But if it's no reasonable grounds case, if they're deciding there isn't reasonable grounds to believe that discrimination occurred, then the party names, everything about the case still remains confidential. But if the case goes reasonable grounds, then our statute says that the party names can be public. And you will see that there's like some reference to what the claim was about, like it's fair housing based on disability, you know. That kind of general information is all that we make publicly available at this time. And then settlement agreements by our statute say that if the parties are so informed, usually we have it written into the settlement agreements that we help the parties craft. Those are public by law, but people sometimes settle separate from us and then the complaint just gets withdrawn. And so everything about that case would remain confidential by us. People often want to stop the other party from saying anything publicly, and that's not covered by our statute. So as far as I'm concerned, anyone could say anything about any discrimination case as long as it's not my office that's saying it. Okay. All right. So now we're going to give like a real bare bones primer on your anti-discrimination protections under state law. We could talk for 8 hours about these laws, but we're going to talk about it for 30 minutes. Okay. And hopefully I can provide some resources for if you're really interested in a certain topic, you can go and research it yourself, look up for more information. So we're going to start talking about fair housing. Under both federal and state fair housing laws, we have what's called unfair housing practices. This is when someone is treated differently or unfairly because they are a member of a legally protected category. So in each of our areas of jurisdiction, we have different legally protected categories. So I have them listed here. I'm not going to read them all out to you, but many of these areas of law are protected both under federal law and under state law. Gender identity is one that is explicitly protected under state law and not as explicitly protected under federal law. However, gender or sex discrimination has been interpreted by the US Supreme Court not that long ago that it includes gender identity protection and sexual orientation protections. What is happening with that at the federal law right now, at the federal level right now, is concerning in that people are trying to change the interpretation that the US Supreme Court has made of those statutory protections. It doesn't matter under state law. These are enshrined in our state law and will not be changed by anything that the federal government is trying to do right now. Okay, and that's kind of the message I'm just going around everywhere I go. No one can mess with our state law. Our state law says what it says, and we can always be enforcing those rights. One of the big areas that's a protected category in Vermont law that isn't protected under federal law is receipt of public assistance. We see this a lot where landlords think they can say, oh, no Section 8 voucher, or oh, you collect SSDI, then that's not, I won't accept that. I won't accept you as a tenant because of that. That is unlawful under state law. So if you hear of that happening, please let us know. It happens all too often. We're going to talk a little bit more about some common examples of cases that we see involving fair housing. So this is kind of just the broad brush. I wanted to have a couple of slides that specifically talk about disability rights in fair housing. People with disabilities have a right to apply for housing and be offered housing on the same basis as tenants without disabilities. You also have the right to be free of harassment or discriminatory statements in your housing because of your disability or any of these other protected classes. And then people with disabilities have additional rights that other protected categories don't have, which is the right to request reasonable accommodations and modifications in housing. Question in the back.
Yeah, I was wondering if you might be able to give an example in the disability and housing realm of like something that definitely would be considered discrimination versus something that maybe somebody brought this case to you and it ended up just being like, this is not a reasonable accommodation or wasn't reasonable grounds for discrimination. I sometimes have trouble knowing where that line is drawn.
Yeah, great question. And I'm going to do a few more slides about
Sorry.
the exact topic. No, I love it. You're just leading me into the next slide. What I appreciate about our housing enforcement actions is that there is a lot of guidance provided by HUD, which we follow. We're not strictly bound by it, but HUD has done an amazing job of creating a lot of guidance documents, both for tenants and renters, as well as for landlords and property managers. And we refer to that stuff all the time in analyzing cases. We do on our website, we do have on the HRC website, we have a tab about fair housing, and under that, it's not pretty, but it has all the content that you would need to get a deeper dive of the different guidance documents that we refer to in interpreting, especially disability rights in housing. I would say that our disability housing cases are the most common specific type of case that we have. Reasonable accommodations is like probably the most common type of disability discrimination that we deal with day in and day out. So I think it's important for folks to have an understanding of how that's defined. Reasonable accommodation request is a request to change any rule, practice, or service that might be needed to give a person with a disability an equal opportunity to use and enjoy a dwelling. Okay, so us in our nerdy lawyer world, each one of these little parts of that sentence has all this stuff attached to it that we understand. So I think it's helpful to give some examples, all right? Common reasonable accommodation requests in housing. A request to be assigned an accessible parking spot, okay? If you're living a place that has parking, but no one's assigned a certain spot, and you are a person with mobility related needs, you can ask to be assigned an accessible parking spot. That's your spot. So you don't have to hope that when you leave your parking spot that was close to your doorway, when you come back, it's going to be gone. You know, that's a very common form of a reasonable accommodation request. Also, if you're a person that has a service dog, request that you be allowed to have your service dog in your building, even if your building has a no dogs policy. That would be an example of a change to the policy of having no dogs that would be required for somebody who has a disability related need for a service dog. Also, a lot of apartments have like a pet fee, but if you have a service dog or an emotional support animal that lives with you because of a disability, waiving that fee would be an example of a reasonable accommodation request. That's like my bread and butter these days. It's like landlords who think they can like charge a person an extra amount because they have an emotional support animal, or that they can just say, no, you can't have an emotional support animal. I could talk to you for an hour about emotional support animals and all of the things that they that landlords can and cannot do associated with that. If you're interested in that, please sign up for my every other month. I do a fair housing training, virtual, which you can access on our website. And we really get into a deep dive on that juicy topic. Yeah.
That apply to hospitality as well, or just permanent housing? Like the charge, like if a hotel charges $50 to have an animal.
Yes, if you have a service animal, and that's in the public accommodations realm, not in housing, so we'll actually be getting to that. But yes, you have a right to be able to have a service animal with you as if, you know, without extra fees or charges or burdens attached to that, because having you have a burden or a fee attached to that would be basically fining you for having a disability. Yeah. Service dogs in public places is also another one that I see way too many of these cases day to day. So another common example is for individuals who struggle with verbal communication. They may request that communications from their landlord be provided in writing so that they have that time that they need to read and digest it, maybe work with a communication specialist to make sure that they're understanding their communications from their landlord. So these are some common examples. And these are like pretty clear to me that denial of these types of things would be something that we would accept for investigation. I am going to talk about when it's okay to deny these types of requests. I want to give you another quick little primer on the other type of special right that people with disabilities have in housing, which is the right to make reasonable modifications. So this is different than an accommodation, which is in housing, which is a change to how things are done. A modification is a change to the premises. It is a change to your unit or to your, entryway that's needed because of a person's disability. So some common examples of this. Most common is like installing grab bars in the shower. Maybe you need a fence in the yard because you have a service dog. Maybe you need a ramp because you're in a wheelchair. Or if you have hearing loss, you may need a light strobe for your smoke alarm or your fire alarm, right? These are kind of very common examples. And generally, the cost of these types of modifications are to be paid by the person making the request. There are some situations like in subsidized housing where the housing provider is on the hook for these kinds of modifications. But generally, folks with disabilities that need these modifications need to be granted permission, but not for them to be actually undertaken at the expense of the landlord. Now, landlords who want to be super inclusive and welcoming can just go ahead and do it themselves, and that's very nice of them, and I encourage them to do that. Not everyone has the means or ability to do that, and there are a few places where folks can apply, folks who need modifications to their housing related to their disability. I think VCIL is one entity that sometimes has some money available to help folks cover those costs. Okay, so there are some instances where these kinds of requests can be denied. So first, if there's no connection between the disability and the requested accommodation or modification, then that's like a pretty obvious no, we're not going to grant that. So for example, I have hearing loss, but I need you to give me a ride to my car. Like that's not, that those things don't have anything to do with each other. So that wouldn't be considered related to a disability. More often we're seeing things get denied because of either an undue burden or what's called fundamental alteration. So an undue burden is where granting the request would impose an undue financial and administrative burden. This is like a tough test and it's kind of a gray area, and it is something that our investigators will look closely at if it's the reason that the request has been denied. But typically a change in how you do things doesn't have a lot of money associated with it. It may be a little bit inconvenient, but that doesn't mean it's undue. That doesn't mean that the burden of you granting that accommodation is undue. So that's going to be a really fact-specific analysis. And we're going to be looking at, like, if it's an expensive change, we're going to be looking at the resources of the housing provider as a whole. Not, so if it's one of these really big housing providers that has millions and millions of dollars, we're going to consider that of whether it's undue for that particular landlord versus a landlord who has 2 units, and has no money. Like we will consider that specific housing provider and whether it's undue for them. And then fundamental alteration is where granting the request would just completely change the nature of the services or the housing provider's business. So some housing providers do provide some kind of like transportation. But if you're not a housing provider in the business of providing transportation for tenants and someone requests that you do that, that would probably be considered a fundamental alteration. So these are all legal terms that lawyers spend lots of time analyzing and researching and considering, and that we could spend lots of time talking about. We're just going to keep on moving on through these slides. I will want to say, though, that before a landlord or housing provider denies a request for an accommodation or a modification, The expectation is they're going to engage in an interactive process with the person who's made the request. You're not just going to say no and that's it. You're going to be talking with the person about what is their disability related need to see if like what they're proposing is way too much. You can't do that, but maybe you could do something else that would still meet their need. And this is a step that sometimes gets skipped. And I also want to say it also does require kind of both parties to come to the table in good faith and try to like solve the problem. And not everybody is always willing to do that, but that is what the law envisions. Okay, so we're going to move on from the topic of disability and housing. So I just want to see if there's any last questions about that. And I will be hanging around for a little while after this if there's other specifics.
I
Yep.
have a question. When does things escalate from state to federal? Like, does that ever happen or?
So in Vermont, our agency is tasked with doing anything under federal law. So when we investigate things that implicate federal law, we dual file it with HUD because we have a contract with HUD to do that. And if HUD gets a complaint that also implicates state law, which they all do, they're going to ask us to do the investigation, and that's our contract. And they're supposed to pay us for that. So we're really hoping they will. Let's start with you.
Do you have any interaction with employer provided housing?
Sometimes,
Okay.
yes, it still fits as housing.
Okay.
Yes. And our housing statute is extremely broad, where really anyone can violate the law. So even a neighbor who's harassing someone because of their gender identity, they can still be subject to this statute and have a complaint filed against them. Question from the computer.
Yeah, thanks for taking my question. Melissa, I work for the Vermont Division for the Blind, and people are always asking about the emotional support animals versus like the guide dog. Now, I know guide dogs are certified, they're specially trained. Are the courts now recognizing emotional support animals as legitimate and that people can have them?
Emotional support animals generally are considered assistance animals and are a right, you have a right to them if there's a disability related need for them in housing. There's a little bit more of a question about whether they are protected in public places as a service animal. Okay, so assistance animal is like the catch-all category, and there's two types of assistance animals: service animals and other animals that support a person with a disability, including emotional support animals. Sometimes people have a disability related need, like a psychiatric condition or an anxiety condition that require that they have an animal with them that does provide emotional support, but it's also trained to perform a certain task when those symptoms arise. And that if it's a dog, is likely to be considered a service dog that can be in public places as well. But in your housing, you have broader rights to have any kind of assistance animal needed for using and enjoying your dwelling under both federal and state law. I get questions about service animals and emotional support animals every single day, and I've never done a training where I don't get questions about them. This is like the hot topic.
Thank you.
Thank you. And I know there was a question in the back that you had earlier, and I didn't mean to not come back to you.
No, great minds think alike,
Okay.
because it already got answered.
Okay, great. One more question?
I'm just curious if you ever see the opposite spectrum of it, where like a landlord is being abused by somebody with disabilities because, you know, their animal is destroying the property or something like.
Yeah, there's all kinds of guidance that HUD offers for us about animals, but basically they have to be not damaging property or presenting a direct threat to people in the housing. Yeah. And landlords are very worried about being taken advantage of because of this right to emotional support animals or assistance animals in housing. And sometimes we see though that that there may be people who take advantage of the system, but what we often see is that folks who have genuine needs for these animals because of their disabilities are kind of punished for it. And that's, so we're always going to be as inclusive and protective of these rights as we can because of those situations. And don't you think we could have spent this whole hour just talking about fair housing? I know, but we're going to just speed along here. Places of public accommodation is another really big area of our enforcement that we see a lot of cases arising in every day. So discrimination is prohibited in any place of public accommodation. Our statute is super broad. This is going to include any place that is open or serving the public in any way. It can be a business, it can be any school, any government office, municipality, police departments, hotels, motels, stores, anything really that's open to the public. And we have all these different legally protected categories in public accommodations. You'll see the list is shorter, right, than it was in housing, and it's shorter than it is in employment, but it's still pretty expansive. So disability is where we see the most cases coming up. But we also see a lot of cases involving race, color, national origin in Vermont, believe it or not. And then religion, sex, sexual orientation, and gender identity are also protected. And then breastfeeding. People have a right to do breastfeeding any place they have a right to be in public, like it or not. And in general, no one can be denied or refused any accommodation, services, or facilities offered by a place of public accommodation because they are a member of one or more legally protected categories. Okay. I really didn't know much about this area of law until I started working at the Human Rights Commission. And I think it's a really important thing for people to be aware of. But this is also where we find our kind of state law version of the Americans with Disabilities Act. So I'm going to focus now just on the subset of public accommodations discrimination involving disability. So people with disabilities do have additional rights under these public accommodations protections that other people do not have. People with disabilities cannot be denied an equal opportunity to participate in the services, facilities, benefits, and offerings of a place of public accommodations. So equal opportunity is often where we're doing some analysis. And then accommodations and services should be offered in the most integrated setting appropriate for the needs of that individual. So rather than exclude them and make them, only have basement access, we want to be seeing if there's a way for them to receive the services in the most integrated setting possible. And public accommodations, like business owners and, managers really need to take necessary steps, and that's like in the statute, necessary steps to ensure that no person with a disability is excluded, denied services, segregated, or otherwise treated differently because of the absence of auxiliary aids and services. Which is a word I can never say. Auxiliary aids and services is defined in the state law. I'm not going to get into it too much, but it often is things that assist people in being able to communicate or access public places. Yep.
I was wondering how emergency situations such as just considering the pandemic, for example, impact this. I'm thinking of maybe, well, most people could medically be vaccinated, for example, some people could not be. And I know there was a good year or so where in order to access a lot of public accommodations, you needed vaccination, things like that. I was wondering how these laws function in times of, a state of emergency.
Great question. The civil rights attorneys were all on fire during COVID about all the legal questions presented by those times and whether or not denying access was necessary because someone might present a direct threat to the health and safety of others. And that is a reason to deny certain accommodations. But so it's always, it's always going to be this fact specific scenario, but nothing about an emergency pandemic situation changes what these rights are under the law. It's just kind of like we're always constantly reevaluating the new information and thinking about ways that we can still offer as much of a public accommodation as possible for all people. I love that question. I wish I could spend the whole day talking about it. I think I was a little ambitious in what I was trying to cover today, and I knew it when I was making the slide. So we're gonna just like, keep going, and then there's gonna come a time where I'm gonna say, okay, my time's up today. And keep looking for opportunities that I can share this information with as many folks as possible in Vermont. So in the public accommodations world, we don't use the concept of reasonable accommodations like we do in housing and like we do in employment. We just use the concept of reasonable modifications, which is kind of the same thing as the accommodations. So this is reasonable changes in policies, practices, or procedures. We're changing how we're doing things because it's necessary to offer goods, services, facilities, or accommodations to individuals with disabilities. So a common example of this is someone who was like, not because of COVID and an underlying disability, was not able to go into a store safely. We saw all these curbside services being offered. That's an example of that's still being used today of an accommodation that may be necessary for someone. It's a change in how you're doing things. It might be a little inconvenient, but it's probably not an undue burden. So we have the same kind of exceptions that we saw in the fair housing rules that apply in places of public accommodation. They also apply in employment. So that fundamental alteration concept, if granting the request would fundamentally change the nature of the services or business. Undue burden. This is another, we've kind of already talked about whether it imposes a financial and administrative burden that is considered undue to that entity. And then I mentioned also the direct threat concept. If an individual poses a direct threat to the health or safety of others, which we cannot eliminate by accommodating them in some other way, then there may be a exception provided under the rules for a reasonable modification request in place of public accommodation. So I'm going to skip over a few of these slides, but they are available to you and you may look them up. And this is some of the other areas of ADA protections that honestly, we don't see that many cases at the Human Rights Commission about ensuring like physical access for people with disabilities. So barrier removal, and this can also be, so we can have a barrier to access based on architecture or based on communication. And there are, it's going to be a similar analysis as we saw with reasonable modifications or accommodations. But the lingo they use with barrier removal is it readily achievable to remove that barrier to enable someone to have access? And this is things like, a curb cut and, having key access keys in hotel rooms that are lower instead of higher up so that someone who's in a wheelchair would still be able to use that. We also enforce accessibility rules under the Vermont access rules, things like accessible parking, ramps and doors for building entry, lower water fountains, and signage about accessibility for people with disabilities. There are other entities in state government that also enforce those. So often if I get a call about inadequate signage for accessible parking spot, I will notify the Division of Fire Safety because they're in charge of those access rules and they'll get that problem dealt with pretty quickly in comparison to my office where it's going to be a few months in an investigation when really there's a way to solve that problem pretty quickly, which is put up the sign. But we do have enforcement authority of those kinds of issues as well. Now I have a slide on service animals in public places and everyone wants to hear about this. So I'm going to just spend a moment on service animals in public places. So a service animal is specifically defined by law. Like I said, it's more narrow than the type of animal that could be providing assistance to somebody in their housing and in where they live. So a service animal in public places is defined as either a dog or a miniature pony. No other animals are service animals. And it must be individually trained to do work or perform tasks for a person with a disability. So the miniature dog thing, or the miniature horse thing, I know, it's so, but I haven't seen a miniature pony yet. But supposedly they live longer and they're easy to train and they're very housebroken and they can hold you up better, right? They're like sturdier. So miniature pony is a option for a service animal. Under state law. So owners and employees cannot prohibit access or entry by a person who's accompanied by a service animal. Service animals are working animals, they're not pets. So a no pet sign isn't going to prohibit someone from going in with a service dog. They may be, and service dogs may be accompanied by a trainer who's not a person with a disability, but that dog needs to get trained somehow. And so we need to allow that animal into public places so that they can learn how to perform their tasks. A person with a disability cannot be asked to remove their service animal from the premises unless that animal is out of control or is not housebroken. Otherwise, you gotta let them in. And there are only 2 questions that a place of public accommodation is allowed to ask a person who's trying to access a public place with a service dog. Is the dog a service animal? And what work or task is the dog trained to perform? A lot of times we see employees asking somebody, what's your disability? That's unlawful. You don't get to know what somebody's disability is. You just need to know that the animal is trained to perform a certain task. And then also we get into a lot of questions about whether they have to wear a vest, whether they have to provide documentation about certification. They do not. Whether they have to be leashed. Sometimes the animal cannot perform its tasks if it's leashed. And so we have seen some cases about that question. And my general advice is to be as welcoming and inclusive to folks who have service dogs as possible, because I've seen firsthand the trauma that happens to individuals who try to access public places with their service dogs and are denied or humiliated because they have a service dog. And they carry that trauma around for life. And every place they go. And then they might decide, I'm not going to go anywhere with my dog, or I'm just not going to go anywhere at all because I can't handle getting asked about this again. And so we are often having to do a lot of education for business owners, especially about people's rights to service animals. Probably going to be a topic that folks want to ask questions about, but I want to be conscious that we're tight on time because I was over ambitious. And I apologize for that. Here is the overview on employment. It's all kind of a similar track of what we saw in housing, what we saw in public accommodations. We have legally protected categories, and people can't be treated differently in their employment because of their membership in that category. When it comes to employment, we really do look to a lot of EEOC guidance. The Equal Employment Opportunity Commission is the federal agency charged with employment discrimination work, and we often rely on some of their interpretation and applying state law. People have a right to reasonable accommodations in their employment. And that was the last slide. So the summary is discrimination and harassment based on legally protected categories is unlawful in these 3 areas of our civil life, which is a lot of our life, right? Where we live, where we go, and where we work. People with disabilities have additional legal rights in all of those places to request changes to how things are set up or how they're done because of their disability-related needs. Our office is here to process complaints and conduct investigations and enforce these statutes as best we can with our very limited resources. So please, I'll hang around for a few more minutes. I'm happy for folks online to be able to ask questions. And if folks want to hang around, I think the next session doesn't start until like 10. So if folks want to ask questions now, it's fair game. Thank you. Please check out the people downstairs. We have a lot of helpful information and pens to post-it notes.
I think we have that before.
Yeah.
That's not Adams. Similar to, do our state laws around gender protection, is that, do we follow federal law or do we have state laws that are stronger for that? Similar to the first topic that you were talking about.
Vermont has a special state law about gender neutral bathrooms. We have enforcement authority out over. The protection, it's not federal law, it's state law. Yes, we do expect.
I was like,
And what the law is,
it's a federal law and, it's not going to trump that law.
so, state law though, if there's a single stall restroom where there's only one person that can use that restroom and you can open and lock that door, that needs to be gender neutral. It cannot be either male or female. It has to be any gender.
Okay, good.
Yeah.
I was not going to derail both disabilities to check a question.
Keep it
But
very
it's like, but I must know.
I must know. And again, I have cards here. If anyone has questions, they want to email me later. I'll do my best to write back to you in a timely way.
And also got some questions.
Okay, cool.
Is there a timeline, like timeline considerations for reasonable accommodation? So
Yes.
what's it? Yeah.
So, and it's very fact specific, but a failure to grant an accommodation in a reasonable amount of time can constitute a refusal or a denial. So it's very fact specific. You want to make sure that there's an interactive process going on. Sometimes people will just do nothing for 8 months and then deny it, and we would consider that a denial. By delay amounts to a denial. It's gonna be pretty specific, and in housing is where we see that issue the most. And so, we're gonna see, was the delay because they needed more information? They were waiting to get some verification letter, or they were going through some permitting process that took a while. Is there a reason for the delay, or was it really just to avoid it? But it's not like there's a hard line rule, like if this amount of time passes, it's definitely a delay that amounts to a denial. It's gonna be really fact specific.
Okay, that's helpful.
But I'll definitely, I'll use we have some guidance from other courts, and some courts require you have to show like that it was like a intentional, avoiding of granting it.
Yeah.
I wouldn't interpret our state law that way, but, if it's getting up to be 4 to 6 months and you still haven't gotten an answer on this,
Yeah.
then I would probably entertain that as a complaint.
Okay, that's helpful. And then my next question, again, going back to the certain side.
Yeah.
That's
It's a hot topic.
Yeah, so my colleague Melissa asked a question. So I work with the Division for the Blind as well. So we're well versed in working with guide dogs in that area. But I think what I'm finding that's popping up is people not necessarily wanting to go with a guide dog, but a service dog, which gets a little murky because we know guide dogs are specifically trained with dogs. It's a very rigorous process. But I guess my question is like, what constitutes as specific to my trailer or individually trained or supporting.
Yeah, and it's not like they have to go get rigorous training from some special
Yeah.
training entity. Oftentimes, we find that the individual with the disability is the person who's the best trainer for their dog to accommodate their needs. So it's really any kind of informal or formal training that the dog has learned that there's a thing that they need to do in a certain set of circumstances that's needed for a person with disability.
Okay.
Yeah, and so it can vary widely of what specific training. And there should not be an expectation that it's something that you pay for or that you go get. You get a certificate. You can individually train the dog. Yeah.
And if, and then some landlords are having fears about, what are what is like the best place for them to reach out to? Yeah, it feels like a murky definition to me. What's happening?
Well, there is guidance from HUD about what is a direct rent. The common example I see of that is people who like, I have a slide based on the breed of the dog, right? But it actually actually has to be a direct dog represented by that specific dog.
Yeah.
Not by the breed of the dog, just type of dog or these types of situations. And so, in terms of like an entity to get support on resolving that conflict, maybe CDOEO could be helpful. There might be like a restorative justice organization, restorative justice center in that community that can help be like a mediator.
Right, that's exactly.
Yeah, one of the positions I'm asking for this year is a mediator in our office so that people can just get the benefit of having someone in between, not attach the outcome, you just help try to get, solve the problem.
Right, and interpret kind of like definitions and things like that, because I think sometimes people agree that it's just, we're not the agree, so that's okay, it's just getting there. Good for you. Well, thank you very much.
Yeah.
Mackenzie. It's very investigation.
Yeah, I know.
Yeah, somebody else has their microphone on. There's a lot of interference. It's hard to hear.
Like, I know that voice.
These people, we're pretty much done. But if folks, want to hit me up personally on Teams later today, I'll be back at my desk and happy to answer questions like all about.
As far as the feels very nice.